All right, hello everybody. We are going to be starting. My name is Amy Forbes. I'm the training manager from the Northwest Mental Health Technology Transfer Center, or as we like to say, the MHTTC. Welcome to today's webinar, Landlord Behavior and Behavioral Health, Dealing with Difficult Landlords, presented by Casey Burton and Elizabeth Powell. Please know this webinar is being recorded. You will get a certificate of attendance that will be emailed to you after this webinar. And we are not able to offer CEUs for this webinar today. I'm going to give a brief overview of our network and some important information before we get started with the presentation. The MHTTC is a nationwide network supported by the Substance Abuse and Mental Health Service Administration, or SAMHSA. Our network includes 10 regional centers and a network coordinating office. And you can see in that pink circle at the top of your screen, our Northwest MHTTC covers HHS Region 10, which includes Alaska, Idaho, Oregon, and Washington. The goal of the Northwest Mental Health Technology Transfer Center is to support mental health related evidence-based practices, heighten awareness, knowledge, and skills of the behavioral health workforce, foster alliances, and address diversity of training needs, and to share free publicly available training and technical assistance. Our area of focus at the Northwest MHTTC is evidence-based practices for psychosis, which includes CBTP and assertive community treatment. However, we also provide a variety of other training topics. Please check out our website where you can register for free webinars and learning communities, watch a recorded webinar, take a free online self-paced course with healthy knowledge, sign up for our weekly newsletter. You can review our resource library, or you can listen to our podcast called Putting It Together. So for today's webinar, we will send a link to the webinar recording, the slides, as well as your certificate of attendance within a couple of weeks after this event today. For communication during this event, please use the chat box if you need to reach out to our staff or you'd like to share respectful comments, greetings, and observations with everyone in attendance. Please do use the Q&A box. And I would like to emphasize this. Please use the Q&A box at any time during the presentation. Get your questions ready. We're going to have a ton of time to go through questions. I will be monitoring the Q&A box to facilitate answering, and will facilitate answering as many questions as possible at the end of the presentation. And also at the end of the presentation, we will be sending out a link to our survey. Please know your feedback is very important to us. We do take it seriously, and we do look at all of them. We are required by SAMHSA to conduct this survey. However, they do not have any official position on the content we provide. And just to share a couple upcoming webinars, you can register for these on our website. On 7/1, we are going to have a presentation on supervising peers. And then on 7/15, a presentation on dementia, delirium, and depression. And I'm happy to welcome and introduce you all to our two presenters. Casey Burton is a senior staff attorney at the Tenant Law Center, which provides eviction prevention and tenant advocacy services to King County in Washington State. Casey has spent several years practicing landlord-tenant law as both a right to counsel attorney for tenants facing eviction and providing eviction prevention assistance, which has allowed her to pursue her passion for housing justice. And we also have Elizabeth Powell, who has been actively practicing law since she was admitted to the Washington Bar in 2000. She volunteered for the King County Housing Justice Project for years and took the knowledge she gained representing tenants facing evictions into her private practice, where she litigated well over 1,000 cases in the last 24 years. Welcome, Casey and Elizabeth. We're so happy to have you here today. Thank you and welcome back. And I will stop sharing and hand it over to you.
Thank you for having us. And yes, as stated, I'm Casey Burton. I've got my colleague Elizabeth Powell here. Elizabeth and I practice in Washington State, so I will clarify up front. A lot of the advice we're going to give is relevant to specifically Washington State, but that said, we are also going to cover some federal law, and that will likely be applicable to a lot of your clients' situations too. Let me see. I'm going to get the presentation sharing hopefully soon. The button will listen. There we go. All right. I'm gonna guess that we all see it because that's what my computer's telling me. So, yeah, thanks for being here, and we are ready to jump right in. So, as always, I like to start out with what we're going to cover. So, we're going to talk a little bit about what constitutes a bad landlord, what types of bad landlords there are. We're going to talk about some common issues and how folks can help their clients. We do have some resources for folks in all the states in the Northwest region. And then, of course, we're going to leave lots of time for questions because we've noticed that folks really like having a lot of time for that. So, I don't know why I'm coughing today. I just want to start out by saying, a bad landlord is a landlord who doesn't follow the law related to their tenants' rights. And that doesn't necessarily mean they're a bad person. You could be a good person and maybe you're just not great at following landlord-tenant law. You don't know, you don't want to know. I mean, there are a lot of reasons, but at the end of the day, it makes life difficult for tenants, and it's really important to learn how to handle those situations. So what kinds of bad landlords are there? So let's say you've got a landlord who's being really aggressive with your client and they are showing up every day, pounding on the door saying, "Where's my rent?" Or, "Why are you doing this? Why are you doing that?" Or perhaps they are making stuff up as they go along. So they are making up notices that don't exist under the law. We see that quite a bit. And, maybe they just don't know the law or they don't want to know the law, as I stated. They're just as there are bad landlords, there are bad tenants. And so we want to recognize that this is just a matter of figuring out how to navigate this particular relationship without, necessarily saying, "Oh, all these people are bad." That's not what we're trying to do here. Sometimes landlords do questionable repairs. They think, "Oh, I'll just duct tape this and then it's fine. It's repaired." That's not good. And that's not in compliance with the law. Like we said, bad notices. Sometimes they're not interested in fulfilling their legal obligations. They just want to passively, accept that income from the rental unit, and they don't want to do repairs. They don't want to handle their responsibilities in general. There are a lot of situations that, can happen. And, by the time tenants come to us, it's not because things are going well.
Right.
And so there are some common problems. So for example, when moving in and signing a contract, and well, actually, Elizabeth, why don't you jump in at this point?
Okay, I'm happy to. The second line in that references the Residential Landlord-Tenant Act in Washington, and then the second references to Washington State law against discrimination. So the biggest problem that I see is, well, when people are moving in, the place isn't ready. The You never had a chance to see it, and then you get there and there's something wrong with it. Or a landlord who hands a tenant a walkthrough checklist and says, "Return this to me eventually." None of that is supposed to be how this works. A tenant is supposed to pay a damage or security deposit after they've had a chance to fill out with the landlord a walkthrough checklist detailing all the conditions inside the apartment. And so a landlord who doesn't understand that because it's too time consuming or too difficult, that's a huge red flag. Similarly, a place that is not ready, that is also a huge red flag. A landlord should be on their absolute best behavior when a tenant is on the verge of handing them a whole bunch of money and the tenant is going to move in. So I would be watching for that really carefully. Tenancies end for various reasons, And sometimes landlords can get really, really amazing about what they think is appropriate for a tenant to do. I have seen checkout lists that say you have to use Q-tips to clean everything in the apartment. And if you don't, we're going to charge you for doing that. And that's not how this works. It's not the tenant's obligation to turn the apartment for the next tenant. That's the landlord's problem. The tenant's obligation is not to damage the place, get it back in shape. And it used to be called normal wear and tear. Now the statute refers to ordinary use of the premises, which I think is a more normal way to look at it. So if you have carpet and you walk across it in a particular area, it's going to get matted down a little bit there. That's ordinary, that's normal. If you bring in a motorcycle and do a build out in the living room and get oil all over everything, that's damage. So
That's
those
okay. Yeah.
extreme examples of what is ordinary use of the premises versus what is not. And also, I have seen landlords that want to charge a tenant for destroying a 32-year-old carpet. That is literally impossible. So, those are arguments that people can have after they get out of a tenancy. There's kind of no point in arguing about it during the tenancy. So, and then the rules about deposits, at least in Washington State, that money it belongs to the tenant, and the landlord gets to essentially hold it in trust through the duration of the tenancy. But it's the tenant's money. And so in the last year or so, our legislature has really clarified what a landlord has to do in order to keep that money. And it's not just waving their hands and saying, well, we had to do a lot of cleaning. That'll be $5,000. No, they've got to be a lot more specific than that. And I think that's going to help. The other thing too is landlords can make it seem as though you must respond to phone calls. You must answer the door when they show up. No. If a landlord has a meaningful communication that they want to make, they need to do it in writing. And so the converse is also true. If a tenant has a communication that needs to go to the landlord, it needs to be in writing. And those of us who are ancient are going to talk about using a pen and a piece of paper and making a copy and delivering it, as opposed to text messages. I find that so problematic. The RLTA was written in 1973. And so when a judge says put it in writing, they're literally looking for a piece of paper. And so, and keeping those and keeping records. So anyway, Casey, go ahead on this one. If you've got other comments.
Yeah, so I mean, I would say that the best thing a tenant can do is figure out what their rights are up front. There are a lot of guides out there on the internet. I know in Washington, for example, we have washingtonlawhelp.org, and they have a lot of great resources for tenants on a lot of different tenant issues. And just making sure that you're protecting yourself by documenting as much as possible, because if you do come across a problem with a landlord, then you're going to want to have a lot of evidence, a good paper trail to back you up. So let's jump into some of those issues. So for example, let's say the landlord's discriminating against your client. They are differently abled, or maybe it's based on race, national origin, sexual orientation. There are a million ways that they could be mistreating someone. And so in Washington, there is the Washington Law Against Discrimination. And the way that tenants are protected is because the statute protects anybody as part of a real estate transaction. Now, if you are leasing property, that is a real estate transaction because you are leasing that real estate. There are some local laws, and I always encourage people to Google, what are my tenant protections in my particular city? Because there are state level protections, but you can add additional protections at a local level, so long as they don't conflict with the state protections. And that's going to be the case throughout the country. The way it works is federal law always wins in certain areas. And then there's state law. And then that's always going to beat out local law, but you can always build on top of those existing, higher power protections, but they just can't conflict. So that's important to know too. Make sure that you know all of your options. At the federal level, the Americans with Disabilities Act requires housing providers, landlords, to not discriminate on the basis of race, gender, handicap, disability, and so on. So there are protections at 2 levels for tenants. You've got, well, 3 levels technically. You've got the federal, and then in many cases you also have state, and you also have local protections. So it's important to remember that you do have options. There are ways to, protect your client. And I would recommend, okay, I see that, for example, my client's landlord is discriminating against them based on their, behavioral health care condition. Okay, so then is that a violation of the law? Probably, most likely. And then what are you going to do? Well, it's important to take the time to tell the landlord, say, okay, I don't know if you're aware, but this person has these protections and this behavior is not okay under the law. And they might say, oh, okay, that's my bad. I apologize. I will change my behavior. That is the ideal outcome, is you educate them and then they do better. Sometimes they won't. And that can be very frustrating. And that is when you want to look at your local legal aid resources. We do have some of those listed at the end of the presentation, like I mentioned, or I think I mentioned, maybe. I think I did. Anyway, and figure out if you can get somebody to step in and help with that enforcement. And it's tough because, I mean, perhaps I'm biased on this opinion, but legal aid is chronically underfunded. And that really limits bandwidth for service providers, as I'm sure all of you know, because you're probably experiencing very similar situations. There's always a funding crunch and you can only do so much. But it's really important that you at least know your client's options so that you can step in and say, hey, landlord, no. And like Elizabeth was talking about, documenting, because then if you, and I'm okay with emails, Elizabeth prefers everything on paper. But you're telling the landlord in writing, hey, this isn't all right. And they say, I don't care, I do what I want. You now have something in writing that's evidence that says they were notified, they are aware that what they're doing is a violation of the law, and they're choosing to do it anyway. So that's really important.
I want to jump in and answer a question that was raised about whether or not this applies to college dorms. No, because that's an institution and the housing is provided as an adjunct service to institutional, process, which is providing a school. And the other thing that a person such as yourselves can always do is to write a letter or a text message. No, this is a letter requesting reasonable accommodation. It does not require that you go into details about exactly what the situation is for your client that requires reasonable accommodation. It's more a generalized, hello, Mr. Landlord, my client requires reasonable accommodation. I believe there is a really good letter in Washington Law Help on that subject that a provider can send to a landlord.
The Fair Housing Center of Washington has a link on their website that helps you fill in a reasonable accommodation request.
Yep.
They'll help put that letter together.
Right.
And if your client is in an educational setting, I would recommend that they look into their rights as a student and those laws, as opposed to fair housing laws, because that would likely be a better route for them to pursue. And on that note, since you mentioned reasonable accommodations, let's say your client, they receive state benefits, and so, but they don't get their check until like the 3rd, and rent's due on the 1st, and the landlord causes stink. Okay, well, I'm getting federal benefits as a reasonable accommodation. Can you please move the due date? And actually in Washington state, if you live off of benefits, and that's why you need to move your due date, that's protected. So, if they refuse a modification or accommodation request, that can be really tough because you're trying to make sure that your client has an equal opportunity to enjoy their living situation, the same opportunity as everybody else who's living there. And pardon me. So if they're refusing to do that, first of all, they're not supposed to categorically just refuse it. They can't just say, oh, no, and then move on. It's supposed to be what's called an interactive conversation. Okay, well, Ms. Landlord, this doesn't work for you. What would work for you? Like, let's figure out something in the middle that meets everybody's needs. And sometimes their refusal might not be reasonable. Maybe they just don't want to do it because they want to have things a certain way, and they're used to being able to have things a certain way. But people have certain protections under the law. So that's another situation. And I might sound a little bit like a broken record, but try to give the information to the landlord, hey, you can't do this, in writing, and say, okay, this is what's required. And then that can potentially open up a new conversation and saying, okay, now I know what I'm supposed to be doing. Let's figure this out. And if they categorically refuse, you're going to want to look into, okay, who can I file a complaint with? If, let's say, your client's in a housing authority owned building, then you can file a complaint with HUD. Or maybe you've got a local organization like we have in Washington, the Fair Housing Center of Washington, that you can file a complaint with. We also have the Human Rights Commission that you can file a complaint with. So think about, if the landlord shuts you down after education, who can I go to get them involved and get this resolved? Did you want to add anything, Elizabeth?
I do. One of the things that I see that landlords have a hard time understanding is that sometimes a situation changes for a tenant during the course of a year-long lease. And when that happens, sometimes the tenant needs reasonable accommodation so that they can continue to enjoy their housing opportunity, which might not work for that tenant anymore. Classic example, tenant breaks their leg. Their apartment is on the 3rd floor and it's only stairs to get up there and they cannot do it. And people are like, well, can they break their lease? Yep, they can, because they can say, dear landlord, I need reasonable accommodation. The accommodation I need is I need to be allowed to leave without further penalty because of this thing that has happened to me. Love and kisses, the tenant. And if the landlord doesn't like it, arguably the landlord could take it to court, or the tenant can start with one of the administrative agencies, or the tenant can just wait and defend it in court. Because judges get this, that sometimes housing just becomes impossible. And that does happen with tenants that are having behavioral issues. Is that a reason to be out of a lease? Absolutely.
And I think one thing I'd like to emphasize in what you just said is that it can be a temporary disability. Let's say, like, you're medicated and everything's going fine, and then, I don't know, something happens and it causes a problem, or maybe a new problem. Then that would be a situation where, okay, this is a temporary disability. Like, I need accommodation of this, even if it's just for a little while. And that might be, okay, I can't live in this unit anymore. Or it might be, I need things to be this way for a while.
Right.
All right, landlord refuses to accept housing subsidy. So in Washington, this is called source of income discrimination. If they say, oh, you have a housing choice voucher, nope, I'm not renting to anybody who has a voucher. That is banned under the law, like 100%, no questions asked. They can't do that. And I would recommend, in that, again, you're going to put something in writing, say, hey, you can't refuse this person just because they have a housing subsidy. And it might not be like a federal housing choice voucher. It might be some other subsidy. Like in Washington, we have the housing and essential needs subsidy for folks. Landlords can't say, oh, well, this is your income. No, I don't. That's too uncertain. I don't want to do that. Well, nothing in life is certain, except for death and taxes. So you've got to make sure they know you can't say no just because of where they're getting their money to pay rent. That's not allowed. And under federal law, that's also protected. Now, as noted here, other states' rules may vary, and you can probably pretty easily Google, hey, is there source of income discrimination protections in my state? Or you can just Google source of income discrimination Idaho, source of income discrimination Iowa, something like that. And that should pop up with whether or not that's protected specifically.
We've had a case in the office recently where the landlord seems to be very confused about whether the tenant is reporting income properly. And as such, they have elected to not accept this person as a tenant. And my advice to that program and that tenant is that he needs to be housed. So this building obviously has set themselves up for a lovely complaint, but that's not going to get them housed. So rather than fighting with somebody who doesn't seem to understand that veterans benefits qualify as income and they don't get to question that, get them rehoused someplace else, and then we can take it to one of the agencies that is going to be interested in that landlord's approach. So, but it's a longer term problem.
And I think that's actually a really important point. Sometimes you sort of have to figure out how you want to fight the battle.
Yeah.
Sometimes it's a matter of, I'm going to assert this right now, and we're going to fight this out right now. Sometimes it's a matter of, okay, I need this person to get housing. They are unhoused right now, and that is not good for them. And so, okay, I'm going to document my problem with this landlord.
Mhm.
But at the same time, I need to try another approach. I need to go find an alternative place for them to apply to that hopefully gets the law, understands what their obligations are, and then do that. And then once that person is stable, then you can go back to fighting that fight with the other landlord and making those complaints. And you'll have all this lovely documentation as evidence.
And in my case, all that lovely documentation is from the landlord. It's amazing. So yeah, but that is a different problem conceptually, because I can't go to war with that particular landlord. And if they need to be persuaded, that's going to need to come from an agency or from a judge. It's not going to be from me. So yeah, get these people housed. So
Yeah.
anyway, yeah, it's
I
it
understand wanting, I'm gonna fight this fight. I'm gonna get this person in this unit. But while you're fighting that fight, they might not have a place to live. So
yep,
that's another strategy consideration.
right,
All right.
right.
Landlord won't repair anything, or they're doing DIY repairs. Now, in some cases, the landlord can repair stuff on their own. There's certain things that they can just go in, fix it themselves, and that's no problem. Now, if they're tearing out the wall and redoing the wiring themselves and they are not an electrician, that's obviously a problem. And so what's really important is, again, put it in writing. And especially in Washington, you can do all the verbal requests for repairs that you want. Your rights are not triggered until you put it in writing. And that is what's most important. You have to say, dear landlord, I am writing to you to say that X has been a problem. I need you to repair it. There are certain timelines in Washington state for, how soon repairs have to do. So like, for example, if your water heater goes out, that's going to be immediate. Whereas if it's a matter of, the handle is kind of messed up on this inner door to my bedroom, they're going to have more time to fix that. And so it's important to consider that too. It might not be immediate depending on what the issue is. And the landlord still has to give notice to enter to do that repair, especially in Washington. They can't just show up and say, well, you wanted the repair, I'm here to do it. Why are you not letting me in? No, no, no. You have to give me notice. And then once you give me notice, it has to be, the 48 hours. It can't be like in the middle of the night. Okay, then we're good. And, unfortunately, federal law, there aren't really protections for this. It's more of a state and local issue, which, causes some confusion, and it's very patchy. But, if it's something where there needs to be a permit involved to do that kind of repair, then you're going to want to start calling code enforcement and say, hey, quick question. My landlord is redoing all the wiring or redoing all the plumbing in the home themselves. And to my knowledge, they are not a master electrician. They don't have any sort of permit. They don't, and not getting permits to do repairs can be a problem. What do I need to do here? I need to file a complaint because that needs to be done properly. Because if it's not done properly, maybe they've played around with wiring, they've done their own electrical work, okay, but it's a matter of safety for the tenant and for your client. And bad wiring can go sideways so fast. What about you, Elizabeth?
Well, I want to pipe up here a little bit. Some landlords in their lease agreement will say, if you have any maintenance needs, we have this website portal where you can submit your maintenance requests. And as far as I'm concerned, that's a great deal, like sending a maintenance request into a black hole. I mean, it's always okay to do that, but you also want to get it on paper. Dear landlord, as I reported to you at 2:30 in the morning last night, the water heater quit working. There's water all over the place. Please get this fixed in the time allowed by the RLTA XOXO client. That document is the basis for going to code enforcement. And also, landlords, okay, people who own property can work on their own property if they live there. If they are not the person who lives there, then they need to go through the proper agency and use somebody with the correct credentials to go do plumbing or electricity. And so, yes, there are some things that a landlord can take care of, but for those, oh boy. So if you frame up this complaint by saying, "Dear code enforcement, here's the letter where I told my landlord that I was having this problem," because that's what they're required to know, is that the landlord knows about the problem and has had adequate time in which to address it, then code enforcement can get involved. But if you just call code enforcement out of the blue, they will frequently say, "Well, we don't get involved in landlord-tenant matters." And then people like me have to call them and say, "Hello, actually, you do." And I have that conversation constantly, but I know that I won't get anywhere without documentation that the tenant told the landlord that there was a problem. So anyway, in Washington's code, 5918.060 lays out all the things landlords have to do. 5918.115 lays out the conditions that could lead a code enforcement person to declare that a property is substandard or needs to be condemned. And those are the ones that really matter. I do not like the color of my cabinets. Okay. But if it's that, dear landlord, there's an outlet in the kitchen, and if I use it, it is sparking and, smoking. And yeah, that is a problem that you want to document and get to the right place. So yeah, it's very, very useful section of the code.
And if you're not sure, I would say call code enforcement. Say, hey, my client's got a landlord. They're doing the repair of this and they're doing it this way. Is that okay? And they'll be able to say, oh yeah, no, that's fine. They can do their own repair in that instance. But if it's a situation where maybe they need a permit, then code enforcement's going to say, actually, I've got concerns about this. Why don't you tell me a little bit more? And then that's an opportunity for both of you, for the code enforcement and for you to learn a little bit more about what's going on and what the client's options are.
Right.
All right, improper eviction notice. So this is probably one that we see the most. So in Washington state, at least, and I recommend you check your local statutes, there are a set number of reasons why you can issue a notice to a tenant. You can't just do an eviction for any reason. You can't say, well, I don't like the way you look, so I'm just going to evict you. Or I don't know, you smell funny. I don't want to continue your tenancy. It's called just cause, and you can only evict a tenant for one of those just cause bases. And so, we see made up notices all the time where man, I see a number of those old pay or vacate. So now it's in Washington, it's 14 days to pay or vacate, but if the CARES Act applies, then it's 30. And that is actually federal. So if you have a client living in a property covered by the CARES Act and it's a pay or vacate, then they are probably entitled to 30 days notice instead of whatever your state statute says, just as a heads up. And they will give like a 3-day pay or vacate, which is not real. And it hasn't been a real thing under the law for a very long time. It used to be like a long time ago, but it's not anymore. And so at that point, you need to make some strategic decisions. Pardon me. And so you have some choices. You can either tell the landlord right away, like, look, this is made up. This is nonsense. You can't do this. But then the landlord's just going to turn around and issue a brand new notice, the correct notice to your tenant. Now, it's not your obligation or your client's obligation to educate the landlord on what they are supposed to be doing under the law. The landlord is running a business. And if you're going to run a business, you need to know the regulations that run your business. And so, it might be worth your client's time to say, okay, you gave me an improper notice. I'm going to wait until you try to move on this. And then you're going to see that it's wrong. And that can be stressful for the client because they don't want to deal with, maybe going through an eviction hearing And even though the notice isn't proper and, no attorney can ever guarantee a specific outcome, but if it's not a real notice under the law, then I'm going to bet dollars to donuts that case is going to get thrown out. And now your client has had extra time to say, find rental assistance or find somewhere new to live or, work out a settlement agreement with the landlord. And so not immediately telling the landlord that they screwed up can be useful, but it's going to depend on your individual circumstances. So that's something to consider too. Elizabeth, what would you like to add?
I saw a notice last month that was like this 3-in-1 10-day. So what the landlord did was he wrote a 30-day notice to comply or vacate. And he said, on this day, you did X. On this other day, you did Y. On this completely different date, you did Z. You have 30 days to comply. That's not the way a notice to comply or vacate works. You don't get to pile 3 of them into one notice, expand the notice period. And the reason being that you want to give a tenant a 10-day notice so that they can comply. And then they could avoid that second compliance issue. And then hopefully there wouldn't be a third one. So I actually on that one saw the email from the landlord to the tenant saying, you better do this. And I piped back up and said, you might want to run that past your lawyers. And oddly enough, that has completely disappeared. And so I figure it's not my place to give legal advice to landlords, but that was just crazy. So anyway, but as a general rule, I don't. I do believe that if a tenant receives a 10-day notice that tracks the law, says, here's what you did wrong. This is where your lease says you can't do that. You need to quit doing that. They're writing back to the landlord within 10 days and saying, okay, I got your notice. That will never happen again. XOXO tenant. That to me is reasonable. But arguing with the landlord about a 14-day notice to pay the rent or vacate, or wanting the landlord to rescind that notice. Now, in the city of Seattle or in the city of Tacoma, that is possible. But in the rest of King County or the state, no, they
You can
don't
ask for them to rescind it, but there's no guarantee that they will.
Correct. And so, but if the landlord chooses to proceed on the basis of a notice that is insufficient, then far be it from you to get in your opponent's way when they are making a stupid mistake. Let the judge explain it to them. And yeah, that's really stressful for a client, but that's what happens when they screw up badly enough.
And I think that it's important too to sort of know what is proper notice. And like I've mentioned before, Washington Law Help has amazing guides. They have a whole guide on this is what the appropriate bases are for a notice. And I would be surprised, I would frankly be shocked if other states did not have that. So, say, okay, what are good bases for eviction? Look up how can a tenant be evicted? What are the reasons a landlord can issue a notice? Because if your client gets a notice and you're like, I don't know, is this good? I mean, if you're in King County, you call the King County Tenant Resource Line and talk to us. But if you're not, then you can figure out what your resources are in your area and say, okay, does this line up? And if it doesn't, then you decide, am I going to talk to the landlord about it? Because maybe you can work it out. Maybe there's a comply or vacate and it's just a misunderstanding, or you need to request a reasonable accommodation. Sometimes it is worth it to step and say, hey, let's figure this out. But if they are going to argue with you and say, no, I'm right, then you sort of have to pick and choose your battles. Is this a battle you're even going to win if they're refusing to back down about a notice that does not comply with the law? So that's worth considering.
I agree.
All right, we got next. Improper notice of rent increase. This has been coming up a lot lately. So I can't speak for other states. Somewhere I have notes about who has rent control and rent stabilization, but I don't have those in front of me. But in Washington state, as of 1981, any regulation of rent increases is banned. So there's no ability whatsoever to regulate rent increases. Landlords can increase the rent as much as they want. I have a client whose rent was literally doubled. And now he's going to have to leave a place he's lived for decades because a new property management company took over and they decided they wanted to make more money off of it, doubled his rent. He can't afford it. and it's outside, you know, how much his subsidy can help with. So that's fun. But if they provide an improper notice of rent increase, it's tough. You can tell that this is a situation where I would say, tell the landlord, you know, hey, well, wait until it's too late for them to change their minds. Like, so let's say you have to, it's 60 days before the end of your lease, and your landlord issued an improper rent increase notice. In Washington, it's a minimum of 60 days. Various localities might say you need to give more notice. So for example, in Seattle, they say, I think it's 180 days. I think it's 180. Yeah. And that's just basically the limited effort to try to do something about how crazy these rent increases are. Like, okay, well, we can't stop them, so let's at least buy people more time. You know, then you would wait until it's too late for them to issue a new notice for upcoming time, and then say, okay, well, you screwed up, and this is not a valid rent increase notice. This is actually how it should have been done. Just give them a little, like, you can copy and paste the blurb of the statute or regulation or whatever you need and email that to them, or put it in a letter and mail it. And then they have to do it properly. And now sometimes they might fight you on it. And then in that case, your client might have to go to small claims court and go there and say, look, they say I owe them this money, and I definitely don't, because they didn't increase my rent properly. I need a court order that, you know, either, you know, grants me a credit for the overpayments that I've made in the meantime, or I need a court order that, you know, releases me from this debt that they say that I have. And small claims is probably going to be your best bet, because, I mean, I guess the alternative would be going through the whole eviction process. And if your whole case hinges on an improper rent increase, it can be a strong argument, but it's a little risky to bet the farm on just this improper rent increase. So, you know, consider, when do I want to tell the landlord that they messed up? Now, if your client's month to month, there's not really much you can do. They'll just reissue the notice, and then, you know, when the appropriate amount of time has passed, then they're good to go. But let's say they sign a lease renewal. And I would just want to note that a lot of places actually require specific language in rent increases. So just giving somebody a new lease does not cut it. And so, for example, in Seattle, you can't just say, okay, well, here's your new lease and your rent's gone up $300. No, there's certain language in the city of Seattle that you have to include with a rent increase. And if it's not in there, then it's not a valid rent increase. So Google, like, okay, does my town have rent increase language requirements? Something like that. Elizabeth?
I agree with you completely. And it's the landlords that own property, especially in Washington State, are the golden children of the citizenry, because we don't have an income tax. And that means that the state runs on tax receipts from people who own property. And so when I say they're the golden children, yeah. And they lobby, and they're in the legislature, and they make decisions. And so when a landlord does something really sloppy with a rent increase notice, there's a risk there that a judge who probably owns the property too is going to say, well, this is just fine. And then, you know, evict a tenant on the basis that the judge thought that notice was just dandy. And so that's the difference of litigation in the trenches versus taking things to the Court of Appeals. And a lot of times when it's an immediate problem right this minute, what can you do? You have to be able to make decisions really quickly, and appellate law doesn't happen really quickly. So anyway, the extended notice periods for rental increases is a effective means of giving people more time to decide what they want to do. And it's kind of a Hobson's choice, because they're like, all right, I'll go find a different place. So they go out and look, and they realize that every other place that they've applied to is asking for that same increased amount of rent. So yeah, I will get on my hobby horse if I'm not careful here. Yeah, it's painful.
Yeah, it's a matter of, you know, do you risk it in litigation? And also, let's say you lose in court and you know that the judge or commissioner was wrong. Can your client afford to appeal? Are they going to have support to do that appeal? It's very unlikely. In the state of Washington, we have a right to counsel for low-income folks. And the housing justice projects that run those programs, they often have appeal teams, but they're very small and they have to pick and choose, like, what's the best case? Because I can only take on so many cases at a time. I mean, unfortunately, we lawyers are human. I know it's hard to believe, but we can only do so much at a given time, take so many cases at a given time. And so
Yeah.
your client going to get the benefit of an appeal? You don't know. So it might be worth it to try to resolve it before it ends up in court. And, maybe you can. And then it's a matter of preparing the client saying, okay, these are your options. And, if you lose in court, let's figure out what your backup plan is going to be, and kind of figuring out longer term, what are the options? What is the plan? What's plan A, B, C, and D? Going through that. All right, landlord acting inappropriately towards a client. So maybe they're just being a creep. Maybe they're spying through the windows. Maybe they're sexually harassing them. All of it is not okay. And so there are certain boundaries, and the tenant can work to say, okay, I'm not going to, you're calling me like 5 times a day, every day. That is not acceptable. I will take your call when you have something to tell me, versus just like complaining about X, Y, or Z. And sometimes the landlords won't listen. And then you do have some options under the Washington state law. Again, this is another situation where federal law is really limited, but that's also for a reason, because federal law can only reach so far. There are limits, and I won't get into preemption and my whole spiel about that. But you can Google preemption and learn all about it if you want to go to law school, which I don't know if I recommend that, but but your options are limited. You can try to get an anti-harassment order against the landlord if it's really egregious, but there's no guarantee that's going to work, because again, it depends on, we all like to think that our justice system is neutral. They're not. Everybody comes to their job with their background behind them, and that informs how they see things, how they assess things, what decisions they make about how to apply stuff. And that can have an impact on your client if they're trying to get an anti-harassment order or protection order against their landlord. So in some cases, your client might have to leave, but under Washington law, they've got protections to do that.
May I?
Well, I'm pausing, waiting for you. I want you to have a chance to
that's
my
what.
life experience. I want you to say stuff too.
Okay, I'm gonna try and do this. The relationship between the landlord and the tenant is bound by statute and also by contract, to the extent that the contract is consistent with the statute, but none of it involves a landlord yelling or being demeaning or slamming doors or just behaving unprofessionally. None of it. And so the other thing that I always think about is the power imbalance between the landlord and the tenant. The landlord is the lord of the land, right? He owns it. Okay. Tenant is paying probably their largest monthly payment of everything they have to pay to that person. That's a whole bunch of money. And so they should be receiving that bundle of goods and services in exchange. But instead, what happens is a tenant tends to think that because they are the lord of the land, that therefore they're an expert on all things having to do with landlord-tenant law, which means a landlord can tell a tenant the craziest things in the world, and the tenant, with all proper intentions, is like, okay, then that's what I have to do. And they believe it. And so when a landlord says, if you do X, that's breaking the lease and I'm going to evict you, and the tenant's like, oh my God, then I can't do that. And I see people who get down that rabbit hole so badly, and they're convinced that the landlord has this incredible power over them. No, they don't. And so the other thing to be,
but there are rules. I said they do, but there are rules.
well, yeah. And then the other thing too is that the universe of real estate is populated by people who think that they're going to make a whole bunch of money without having to do anything. That's that passive income idea. And there's nothing passive about being a landlord, which is why the really big landlords have property managers, because there's always something that needs to be done. And property managers, there are no educational requirements. There's nothing. I mean, it'd be great if they weren't felons, but there's no education, no training, no nothing that a property manager needs other than a little, name tag that says, hello, I'm the property manager. And sometimes those people feel disrespected. And so they make up all kinds of stuff that has nothing to do with the law. And tenants, conversely, are like, oh, well, if she says so or he says so, then I have to do that. And that's just sad. I spend a lot of time with people who call in trying to explain to them that their landlord is just making this up. And that can be very difficult. But if you pull back just a little bit, look at the law, look at the contracts, see what they say, you're going to have a much clearer picture of what the tenant gets and is responsible for in exchange. But that's a lot of money to be treated badly. And so I always want to remind people of that.
Yeah, never take legal advice from your landlord.
Yeah.
Or working on you, trust but verify.
Right. Right.
And yeah, I mean, I'm sure that a lot of folks see that there's a ton of turnover for property managers, probably even where you all live, because there isn't a training requirement. And I understand why property managers get frustrated because they're thrown into this situation that's regulated, but they don't always get training. And they're trying to navigate these complicated relationships that are very regulated. They don't have information on how to handle it. And then, they're like, screw this, I'm out of here. And then
Right.
starts all over again with another property manager.
Yeah.
I personally don't take issue with felons. Everybody makes mistakes.
Right.
But,
Fair enough.
so yeah, I would say just think of document. If something's going on. And you know what? Let's say that the property manager is like sexually harassing your client. Have them keep it like a log or a journal. Okay, I went to the office to ask them about X or Y, and they said yada, yada, yada. Now, I won't get too far into the hearsay rule, but basically you're not supposed to testify about what someone else said. But if you have what's called a contemporaneous recorded recollection, you're far more likely to get that evidence in because it's something in writing from about the same time as the event occurred, and therefore is likely, according to the law, to be a fairly accurate representation of what was said in the conversation. So it's really important that your clients are tracking what's going on if this is a problem.
And I want to bring up something else too. Washington is a two-party consent state for actually recording somebody. And that is different all over the country. I don't know, but I know that there are other states where you don't have to get the other person's permission. But a contemporaneous written record, that's not subject to issues regarding disclosure. So that can be very useful. I've counseled people. Yeah.
Don't tell your clients that they cannot secretly record their landlord in Washington state. Don't know. Sorry, keep going, Elizabeth.
Okay, thank you. But for example, I always counsel people to go make their payment of their current rent. And some landlords are like, no, we won't accept it. And there's all kinds of reasons why they want to do it. And most of them are nonsense because the law says if the tenant walks in with the correct amount of rent, the landlord's supposed to take that money and apply it to rent. And there may be some kind of back unpaid rent due from the past, but not that current rent. And so if they won't take it, what I have the client do is to go in with a piece of paper asking for a receipt, because a money order, you might as well be walking in with a handful of cash. And so it would say, on this day, I came to the office with $600 and I'm here to pay it, right? And then ask the landlord to sign that they received it. And if the landlord won't sign it, then the tenant should write, refuse to sign, and keep that paper, because that's a contemporaneous record that the client was there on time to pay their current amount of rent. And that is the kind of thing that can prove to a court when the landlord says, well, you haven't paid rent. Well, actually, I was trying, because the only thing the tenant can do is the tender of the rent, which is the tenant walking in. Oh, and that reminds me too. A lot of landlords would really prefer that this all happens online. So they have a portal where a tenant makes a ACH transfer of money to the landlord once a month. Some people want it set up automatically. Okay, they can do that. But they also, under Washington law, must provide a physical address where the tenant can pay rent with a physical instrument. And that's not optional. It's mandatory. They have to. And they can make that very difficult, but they have to.
And to get back to sort of, how landlords are treating your client, if you are concerned about your client's safety, it may be worth, as noted in the slide, to contact law enforcement and say, they're right outside my door, and you call up the police and say, there's someone pounding at my door. I'm really concerned about my safety. And, if they learn that it's your landlord, they might say, oh, well, that's a civil matter. It's a landlord-tenant issue. Tell your client to demand that they still file a report, and then get that report number. Because unfortunately, we see a lot of times where tenants call the police because their landlord's acting inappropriately towards them, and they're saying, oh, well, it's a civil issue. It's not for us. I don't care. Get a report number, because that needs to be documented through the police too. And you can potentially leave if your landlord is harassing you and behaving inappropriately. And the statute about that is cited in here. There's also a guide on Washington Law Help if your landlord is harassing you and making you feel unsafe, on the proper procedure to leave. So check your local statutes to see if there's any procedures related to a proper way to leave if your landlord's sexually harassing you generally, making you feel unsafe, anything like that.
I want to pop in and talk about summoning a policeman, because there's a time and a place to do that. If a client or a person picks up the phone and dials 911, which is what they prefer, they don't want you coming to the police station. They think that's really weird. And the minute the operator picks up the line, the tenant's going to say whatever they want. There's a record that's generated from that point. It's called a CAD record, CAD. I don't know what that stands for, but there's a record. And so a lot of times tenants that are being pushed around by a landlord really want a police officer to give their landlord a hard time or do something. That's not what police officers do. What police officers do is take reports. So if you say to the officer, I need to make a report about this thing that just happened, there's a report happening, the CAD system. And even if the officer says, well, that's a civil matter, I can't help you, it doesn't matter what the officer's opinion is. It matters that the report get made. So that's the important thing. So if the tenant needs to say at 11 o'clock last night, or, a few minutes ago, my landlord was pounding on my door, I know no reason why they need to be here doing this. There's no notices, no nothing. They're just demanding to come in. And that the officer says, well, I can't help you with that. No, I'm not asking you to help me with that. I'm asking you to take a report.
Yep.
Yeah.
All right, so here's a list of resources for Washington State. And, a lot of works that we've referenced throughout the presentation. Fair Housing Center, they're a great place to file complaints about discrimination. They also have a lot of really good resources on their webpage, including that link on their site to help you fill in your very own reasonable accommodation letter. Just walks you through it. You just fill in the blanks, and then it generates it for you to do. The Human Rights Commission, Disability Rights Washington. Of course, we have, the Disabilities Administration through DSHS. So those are some good places to, at the very least, start if you are looking for some more information. And I should have put Washington Law Help on here, but I didn't. So WashingtonLawHelp.org. They've got a ton of guides, and for all sorts of areas of law, actually, including family law, which a lot of folks need help for. And our lovely intern, Dylan Ritter, we've been so lucky with our really good interns. Stephen helped me with the last presentation, or the one before, and now Dylan helped me with this one. So here are some resources for the other states in this region. For you to at least, can be a great starting point if you need more information, or you have concerns, or your client wants to call somebody and get their questions answered about, well, what do I do about, X, Y, or Z? These are some good places to start. Questions. Let's see if I can move I assume the Q&A is just like taking up the entire, okay, I moved it to my other screen. All right, Kimberly, Is there an agency to report a bad property management company to? You can try filing a complaint with the Attorney General's office for your state. But generally there's no law against being a jerk until it becomes a problem and you start hurting someone or like making them feel unsafe, or it becomes just like so much and you're just not stopping. If they're just generally bad at their jobs, unfortunately, not really. I know last legislative session in Washington, part of the rent stabilization bill that was proposed included like a housing center that would do education for landlord and tenants, and probably could have been a place to file complaints. But I would say, you know, you might need to just keep your own internal spreadsheet of, we don't refer clients to these landlords anymore. It's pretty frustrating because there aren't that many options. We have a client who received a notice for yelling and threatening another resident. Sounds like one resident word against another without proof. What proof is needed in this type of situation? So if you're in Washington, it would depend on what was being yelled. Like if they're threatening somebody, that's going to be a problem. If they were just yelling and getting an argument, that probably wouldn't arise to a basis for eviction, because people get in arguments, it happens. And yeah, yelling is not a great way to approach conflict, but some folks do it. And if they're trying to move forward just on the basis of that yelling, it's tough, because basically it would come down to a he said, she said, or he said, whatever sort of situation. And it would come down to who the court believes is credible. And that's why no attorney can guarantee a specific outcome in court, because who the court thinks is credible depends entirely on who's sitting on the bench. What do you think, Elizabeth?
And who's sitting in the witness chair. So anyway, yeah, and that is highly problematic. Where's the questions that were being asked?
If you get the Q&A.
Yeah, and I was going to suggest, I apologize, there's many questions. So maybe starting at the very top so that I can help filter them out too as we go would be very much appreciated. The first one is at 10:12 a.m. from Anonymous.
Oh, okay. I'm going to scroll to the other end. Sorry.
Yeah, there's a lot of them.
Oh, there we go. Okay.
Thank you, everybody.
Yeah, no, thank you for letting us know. Can a landlord property management company demand the tenant pays for carpet cleaning post move out, and that'll be taken out from the deposit? Is it enforceable if it's in a lease communicated from the very beginning? So if it's a non-refundable fee, it is not a deposit under Washington state law. And furthermore, if they, like Elizabeth said, it's not the tenant's job to make the unit ready for the next tenant. It is your job to make sure that it's not a mess, like you've swept it out, you vacuumed or whatever. I take pictures when you move in and take pictures when you move out, because that is really good protection. Video is tough to share with the court, so pictures are better. And they can do a cleaning fee, but it has to be separate from the deposit. And they also can't just randomly deduct from the deposit, like, oh, you messed up the carpet. If the carpet was fine, there aren't any stains, they just wanted it cleaned and they wanted it professionally restored. It is not the tenant's job to professionally restore the unit. What do you think, Elizabeth?
I agree completely. Excuse me. I agree completely. It's the tenant's job to properly use whatever is supplied in the apartment. And at the end of the tenancy, if there's any evidence of damage, to have a minute to undo it. So people have the nerve, the temerity to put pictures on the wall. Okay, take down the picture, make sure the wall's clean, and if there's a tiny little hole, get some spackle.
Yep. And you can usually get like paint matching and stuff at like Lowe's or whatever.
Right.
Yeah.
How?
Sorry. Go on. No, please. Nope, it's your turn.
Okay, that's my comment. I'm putting things back together again, is to eliminate or restore anything that was damaged. And I also want to touch on, in Washington State, a fee has to be identified in the lease as a fee, and it's not refundable under any circumstances. And a deposit, again, is the tenant's money, which the landlord's going to hold to make sure that the tenant honors all their obligations. There's also this really weird thing where people are paying a monthly fee as
the security deposit alternative. That's allowed under law now.
Right, it is. And I just think that's completely crazy, but that's me. Anyway, but there's also this thing where a landlord says, I am taking a holding fee. and you're going to pay me $500 and I'm going to take this place off the market. And then if I, the landlord, decide that I don't want you as a tenant, I will refund that money and we're done. If you, the tenant, decide you don't want to move here, then I'm going to keep that as liquidated damages. And that seems to fly. And then if the tenant moves in, that becomes the deposit for the apartment. So it's a little interesting how they work that, but it seems to be enforceable and courts are doing that.
It
So
actually goes to the next question. Many landlords ask for a holding fee that is applied to the security deposit once the client moves in. Does the holding fee still allow the 6-month payment plan that is stated in landlord-tenant laws when a client signs a 12-month lease? So the holding fee, it has to be in writing, like what the terms would be for them to keep it. And if the client moves in, then they have to either apply that to the first month's rent or the security deposit. Oh, I don't know where the question went. I lost it. Oh, yeah, here we go. And my thing just scrolled down. And you do have the right to the installment payment plan in Washington State, and some local places have even better installment payment plans for those moving costs. But that only applies if the landlord requires first month's rent, last month's rent, and a security deposit. And that's when you have the right to do the installment payment plan, but that doesn't apply to the holding fee. However, you can still say, okay, you have my holding fee, it's going towards whatever. So I want you to do that, but then also the rest of it, I am doing on the installment payment plan under the law if your client meets the requirements, if it's the first, last, and security deposit.
the other trend is asking for a much smaller deposit. And I think that's just reflecting economic reality, but also it's tracking the terms of returning a deposit. And that's found at 18280. And
You
that,
remember, I can't.
well, okay, but the third section of that says no matter what the RLTA says, a landlord can come after the tenant for damage done to the unit that's in excess of the amount of the deposit. It's right there. It says nothing matters if things are damaged. And so I brought that up with courts a couple of times successfully because I think that's nonsense. Okay, but the point being that if a landlord has a smaller deposit, it's actually easier for them to demonstrate to a court that damage is in excess of that smaller deposit, especially coupled with the new rules about giving them 30 days to come up with the invoices, receipts, actual costs. It's a lot more specific these days. And that is why it is so handy to take pictures, because words are descriptions. Landlords will say, this place is filthy. And that conjures up images in people's minds. But if the tenant takes pictures showing under the sink, inside the oven, behind the fridge, behind the toilet, under the bathroom sink, and can demonstrate that nothing's filthy, nothing is coated in dust and bugs and ick, those are facts. And judges want to know what the facts are, not the property manager's opinion about the facts. So good reason to do it. Okay.
Next, are emails acceptable for writing / paper trail? Now, Elizabeth says, if you ask 2 attorneys, you'll get 3 opinions. I think yes. Elizabeth prefers everything in paper. I think that in this day and age, everybody uses email. Snail mail is slow. If you have an issue that you need to be talking about the landlord with in pretty rapid succession because you're trying to iron something out, I think email is fine. But Elizabeth prefers everything in writing. So I would say qualified, yes, it's fine. Biggest problem I see in my tenant advocacy is that even if a landlord isn't following the law, the tenant is forced to obtain a attorney. Yeah, there's like a huge power imbalance because it's like, hi, I can make you homeless. And another person's like, please don't do that. And so that's just like pretty big disparity of like the person who can make someone homeless and the person who can become homeless. That's yeah, quite the power. And it's frustrating because sometimes landlords do double down and they're just like, no, I'm going to do what I want. And like, you can tell them till the cows come home. No, this is in violation of the law. And literally here, look at this. This is the statute right here. Do you see it with your eyes? Are you reading it? And you see how you're not you're acting in violation of it. And they're like, no, I do what I want. And it's frustrating. And I don't know what the solution is.
I often think about that when I'm in court with a tenant, and I have not said this out loud, but my brain is thinking this. Everybody in this room knows where they are going to go sleep that night,
Mhm.
except the tenant. And what the tenant is risking, at least in their mind, is that they could be homeless. And that happens too often. And so, what we try to do is educate people to help them avoid that outcome. And then, if that is simply not possible, educate them about the process so they quit freaking out that the sheriff's going to show up the next day, because there's a whole legal process involved. And right now in King County, that's taking a while. Oh, well. And so we want to make sure that people are using their brains to make improvements to their systems rather than just having a stationary panic of, oh my God. And the landlord will say this, sheriff's going to be here tomorrow. It's not how it works. So we want
You
them
can't
to,
just call the sheriff and then they remove you. You have to get the court order, and that's the whole thing.
it is, and it takes time. So, okay, how do you prove that your client's being discriminated against? That's the big trick. Um, One of the ways that HUD will check is to send in ringers, which is people who are going to present as somebody different than your client, and they'll ask to apply for housing. And sometimes the landlord is like, why, yes, Mr. and Mrs. White, young couple, come right in. Let's sign you up for a lease. And then if they go in with a, I don't know, two gay black women, and the landlord's like, nope, we don't have anything for you. That can be really good proof that there is something different going on between the way one group of people is being treated and the way another set of people is being treated. And yeah, they do that. So when I have had clients complaining about their landlord, using racial slurs, it's really tough unless there's some other contemporaneous witness who is willing to pipe up and say, yeah, I heard the landlord say that.
Where that logger journal comes in. You're just, and again, it does come down to who the judge thinks is credible, but at the very least, you then have like a log of what's been going on. And it's a lot harder to make the tenant seem like they're not credible if they've got this really good record of what happened.
Yeah, so that can be done. But sometimes when it comes down to the what does this person say versus what that person says, it's credibility. That's it. That's all you got. So making a record, like Casey said. Okay, so do disability legal protections prevent lease violations for symptoms? Say someone yells for reasons related to behavioral health. Where would the law fall when their symptoms cause disruption for other tenants? That's a really good one. Let's say that this hypothetical person has Tourette's and they yell or they swear or whatever. Um, that would be for a person who's providing them with services, opportunity for education to explain why appropriate or not, but they need to investigate other ways to express their disability issues. I am not trying to be rude. I'm trying to be clear. If you live in an environment where people are right next to each other and there's no soundproofing, that's going to be tough. I get it. So maybe the reasonable accommodation would be to move to a different place with better soundproofing. That could work, right? And so the same thing with people who work at night and make all kinds of noise at midnight or something. Is that a problem for the people that live below them? The idea being that tenants get what's called the covenant of quiet enjoyment. And that means they get to quietly have and enjoy their tenancy so long as they're in compliance with all the various rules. Is that always perfect? No. Does it sometimes impact other people? Yeah, it does. And so the limit is when one person says, I can't live like this anymore, and somebody could lose their housing over that. And it's gross, it's horrible. And asking for reasonable accommodation is definitely a way to get the discussion on the correct grounds, right? So, but that's a really tough one. Okay, I'm gonna back up to the
I see, oh wait, shoot, I had scrolled down again. Okay.
Yeah.
Landlord's property manager refused/denied reasonable accommodation request for an appeal of a housing application. Can they outright refuse without giving an explanation as to why they refuse? In Washington State, they have to tell you in writing why they are refusing your client's application. They have to say, this is why you've been denied. If they are refusing to give and you know, that's a real weird situation. Because you can provide additional information after the denial to say, hey, it sounds like you don't have the full picture. Let's talk about this. This is, you know, what's going on. And, you know, I'm requesting a reasonable accommodation in that you would like ignore X, Y, or Z on the record because something happened related to the disability. If they're outright refusing, that's kind of a red flag. And that's when you would want to start reaching out to some of your local resources to see what your options are, because that doesn't smell right to me.
What time in the question and answer are you up to?
I've scrolled all the way back to the top. I was at 10:21. Now I'm at 10:22.
Okay,
What would be an example of a landlord displaying discrimination against a tenant who struggles with high acuity mental health symptoms? I mean, it can be as simple as bullying, because I talked to a client recently who was dealing with that. And, you know, encouraging the other tenants to treat that tenant a certain way. You know, increasing only their rent, refusing to do repairs. Elizabeth, what do you think?
I agree. Those are good examples. And also there can be sort of an attitude of animus. And I've also seen that taken to, in this case, it was the Office of Civil Rights in Tacoma, and that was resolved with an award to that tenant because the landlord was just unrepentant. He thought it was perfectly appropriate for him to approach this person in a manner that was just incredibly disrespectful. And then he came to the hearing and he was doing the same thing. Guess what? In tort law, the only thing the court can do is make one party pay another party for behaving badly. So is it going to be a lot? No. Is it going to be something? Yeah, it is. And that's going to help. So, uh, okay, I'm up to 1026.
I have 10:22. I think it jumps
Sure,
as people
go
have
back.
questions.
Yeah.
So landlord that is nitpicking everything my client is doing to the point where they have asked the client to let them know when he's making meat in his apartment. The landlord lives in the apartment right next to the client. I feel like they're discriminating due to him having a mental health issues, but I'm not sure if this can be proved. How can I prove this or let them? That's so dumb. They can't ask them to, no, no. They can't just demand, like, tell me when you're making meat. Like,
And
no.
so if you wanted to be ridiculously polite, you'd write a letter that says, Dear landlord, I have carefully checked my client's rental agreement, and I see nothing that addresses my client's obligation to inform you when they are cooking meat in their apartment or whatever. Okay. So, should you require further legal advice, you'll need to talk to your very own legal advisor. Throw it back at them. So anyway, yeah, that's a way to do it.
We've discussed a fair housing accommodation letter, and there was a template on some website where it can be found again. Oh, that's, I'll post it in the Fair House, well, actually, it's Fair Housing Center of Washington. Let me make sure I've got the
We're
link.
jumping around again.
I am at, oh, shoot, did I jump? No, I'm at 10:24. I'm
Okay.
typing the answer and I'm copying and pasting the link. Oops, if it'll let me. Okay, or not, be rude.
Well, it says you're typing.
Okay, yeah, and so you just play around on the, yeah, there you go, perfect. And Emma Burridge in the chat just did that, posted it. Thank you, Emma. Can landlords refuse to accept a promissory letter from a voucher program, for example, for a deposit or promise to pay rent? What's the basis for their denial? That would be my question. I mean, if you're saying I've got the money that you need, it's right here, then they can't really say, oh, well, I don't like where it came from. I would say that is a potential source of income discrimination issue. Elizabeth?
I agree. And in Washington, the law really specifically points out what a landlord's obligations are in regard to a pledge and time to put it together. I know from experience that you can have a client who rises to the top of being ready and able to receive assistance at the exact same time that an organization has the money for them. And it's kind of like two Ferris wheels going in the opposite direction. And you got to get there at the exact right minute. And so for there to be the landlord saying, no, we don't want it, that's not going to work in Washington State. Typically, what the excuse is they'll say it's not sufficient. And we always counter with, but the landlord has an obligation to mitigate their damages. And so if you accept $3,000 from this program and then get the tenant on a repayment plan for the other $500 or whatever it is, then the tenancy can continue. And we push that pretty hard. And generally, we can get that worked out with landlords' attorneys if if it's just a rent dispute. So,
The next
that
1025.
where are you?
1025. Can y'all speak more about the federal protection for source of income discrimination? You love this one, so have at.
We don't think it exists. We
Well, you
think
got
that,
some slides. Let me see here.
yeah, but
Oh, does not prohibit. Okay. Yeah, but there are a lot of local rules. And I was reading a study recently that like SOID, we call them SOID, SOID, source of income discrimination. Those laws have a major impact on people's ability to use their vouchers. So yeah, it sounds like it's not codified in federal law,
it's
but check your state and local areas because you might have protections there. In Washington State, it is explicitly protected under our statute.
and I know it's frustrating for you folks that are not in Washington State. I understand the frustration, but understand our frustration that our licenses are confined to Washington law. We can talk about federal because that applies here too, but neither of us can talk to anybody definitively about what the law is in Iowa or Idaho. We can't. It's not that we wouldn't, because we love to talk, but cannot. Okay, so
Are there any laws regarding infestation of bed bugs? So under Washington law, it is the landlord's obligation to manage pests. And the landlords, we see this all the time. The landlord's like, okay, I'm charging you to get the bed bugs situation squared. No, I keep doing this, just no. Because unless the landlord can prove somehow that it was your client that brought the bed bugs in, and usually it's a situation where the client's been living there for a few months, and all of a sudden they're like, wait a second, I see bed bugs. That's not a situation where your client probably brought them in. So it's under the statute is the landlord's obligation to manage infestations.
at all times during the tenancy in multifamily properties, because the little critters go between the walls. In single family properties in Washington State, a landlord has to provide pest-free housing at the beginning of the tenancy, and then it becomes the tenant's problem. So getting some kind of a certificate or proof or something from a pest control company saying, yep, we were here on this date, everything's fine. Otherwise, I would argue that having failed to provide pest-free properties, that the landlord continues to have an obligation in single family. So, okay, I'm up to 1026. Signed a lease that says they're responsible for repairs. Okay.
And no renewal leases since 2021.
Washington State 5918-230 says no lease or other agreement can make the tenant do something that's inconsistent with this statute. And to the extent that it does, that portion of the lease is void as against public policy and shall be unenforceable. What I mean by that is even if the lease says, I promise I'm going to do all the repairs on this house, that section is void. It cannot be enforced, even if the tenant signed it. People think that contracts are like, I'm signing in blood, I have to do this. No. If there's a dispute between the statute and the contract, statute always wins. each and every time.
I did see a quick thing about source of income discrimination in California, and I feel like California would have a statute about that because they mentioned that the rent, they always make the rent higher for the subsidy tenants, and I would definitely look into your local, because I know they have housing legal aid people down there. I can't remember them offhand, but I feel like
Oh, they do.
I've looked at their websites for when we were researching that small claims clinic. If a tenant moves in without the apartment being ready, such as appliances, can they still charge them rent? I would not move into that unit if it is not ready, because then once you're in there, it's a pickle. Yeah, that's tough. I would say that you would probably demand a decrease in the rent because you're not getting what you are supposed to be getting under the agreement. Like you contracted for, I'm going to get this unit that I can live in for this amount of money, but you can't live in a unit without like a stove or something. So
Right. I would just tell the client to get their money back and find a different landlord that has more regard for them. Landlords are theoretically on their very best behavior at the beginning of a tenancy. And if that landlord is being disrespectful at that point by saying, oh yeah, go ahead and move in, doesn't have a bathroom, doesn't have a kitchen, you'll be fine. That's completely disrespectful. Go find somebody else.
yeah, and I would say that in that case, you could look at 09, or sorry, RCW 5918-090, because if your client says, I'm in writing, I am requesting that you get your stuff together and you put the appliances in here, and then time passes and they don't do it, then the landlord has broken the lease by failing to deliver what they promised, and then the client can leave.
Yep.
Just putting it in writing, include using tenant portal to create a work order. So what I do, because I have that at my apartment, take a screenshot. Every single time you submit a work order, take a screenshot, because you might need that later on. And then if they fail to do the repair after doing the maintenance request in the portal, then yeah, I would do a letter email.
And what I would say is you can use it as a backup. So buttons and suspenders. Here's my website portal request. And then your written letter says, I submitted a website portal request on date at time. I'm backing it up with this written communication. Please do X, Y, and Z. So do both. So, okay, I'm on to landlords often refuse to take rent assistance into consideration.
What does
There's
that mean? Like they won't accept the subsidy, or they're calculating rent wrong? Because in Washington, the way, if let's say you have to make 3 times the rent, they have to deduct the subsidy, and then whatever is the tenant's portion, then that the client has to make the multiplier of just that portion, not the entire amount. They have to deduct the subsidy first. So is that what you mean? Well, Elizabeth, you seem like you understand.
No, I get it. And I realize that for landlords, the idea that they have to calculate this correctly, and some of them take it really seriously and they're still really wrong. And so just kind of generally saying, well, I'm not going to take the assistance into consideration, then perhaps the thing to do is to take that to fair housing. This person won't take rent assistance into consideration. Let them come down on them. Okay.
How should someone handle a landlord that refuses to take action or resolve a person's right to quit enjoyment living? Okay, so neighbor from hell situation.
Yeah.
Well, you submit the request that they address the issue, and then if they fail to address it, then they have breached the tenant's right to quiet enjoyment, and they have therefore the landlord, have broken the lease, and the tenant can leave. You can't make the landlord do anything about the other tenant, unfortunately. Oh gosh, yeah, we're running up. Okay, I'm really sorry. So I'm gonna put my email if have Washington law questions. Elizabeth and I are your gals. I'm just putting my email in there in the chat. Feel free to reach out. And the slides will be sent out. And thank you for all of your amazing questions. I wish we could have gotten to all of them. We probably could have spent like 3 hours. But yeah, thank you for being.
I was going to say the same thing. This could have been a whole presentation with the Q&A. I thank everybody so much for putting in your questions.
Yeah.
And apologize for not getting to all of them. There were so many and so many great questions. And hopefully this will just, get the juices flowing to reach out to your local centers, information, reading up on laws, working with clients about housing. This is so important. Elizabeth and Casey have been with us. This is their 4th webinar, and we really so much appreciate your time. Thank you so much for being here. So those of you that are here, please do check out our website. I think the link was put in the chat too, to their other presentations, which have tons of information. So thank you both so very much. And we are out of time. So thank you all for being here so much.
Yes, thank you for coming.